We're live.
Good afternoon. It is February 11th, 2022, and this is a voting session, the first voting session of the 2022 session for the House Judiciary Committee. We've got a number of pieces of legislation that we're going to be addressing here this afternoon. There are three pieces of legislation, however, we will seek to take quickly as they are all pieces of legislation that people have withdrawn. So the motion on these will be for an unfavorable on House Bills 168, House Bill 207, and House Bill 736. Again, these are withdrawn by the sponsors, and that's Delegate Cham with 168, Delegate Attar with 207, and Delegate Cham again with 736.
Move unfavorable.
There's a motion for an unfavorable in a second.
Second.
And all in favor of the unfavorable withdrawn, please raise your hands. 1, 2, 3, 4, 5, 6. I think, yeah, okay. 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. All right, motion carries and it's withdrawn. All right, those three are withdrawn and motion for unfavorable. The first bill we have is House Bill 70, Delegate Rosenberg's bill on SLAPP suits. I believe that this is in the same position as the bill was when it left the House last year. So the idea is that we're sending it back to the Senate in the same condition that we sent it last year. Is there discussion on House Bill 70?
Move favorable.
There's a motion for a favorable. Is there a second?
Second.
Motion for favorable in a second. Actually, now is the time when we do whether there should be discussion. Now, Delegate McComas. You're muted, Delegate McComas.
I guess I read some of the opposition testimony, and the only thing I'm concerned, and I am not a First Amendment expert at all, was the concern over the use of it to basically thwart speech. We had some that were concerned about the young man, I think it was Sandman, that sued, I guess, the Washington Post or something. You know, they kind of said that he was taunting the Indian or something, and that situation. And then also the abortion, the anti-abortion Catholic Conference was, I guess, Maryland Right to Life. They were concerned about it. And I wish maybe somebody might elucidate that, because I read the written testimony and there seems to be some fear over that, and I'm kind of concerned because I've voted for this in the past because I've seen people injured by it is a SLAPP suit is very chilling to free speech when you go after people. So it's kind of curious to get some thoughts on this.
Delegate Cardin, putting you on the spot a little bit, but Delegate Cardin, your subcommittee dealt with this last year. Do you want to talk to those issues?
Just briefly. I mean, I think that I find it curious that the argument came out. We've been dealing with this bill now since I came back, so since at least 2018, and it's usually the other side that the folks like the Right to Life folks would be worried about their speech being imposed on, and that's what this bill actually allows. It doesn't stop somebody. It prohibits the use of lawsuits to stop somebody's speech. So I mean, I don't find a lot of credence to it that it came out late this year, but I'm happy to give you an example of how you know how it works. Basically, somebody files a lawsuit to try and inhibit the ability of whether it be a newspaper or a blogger or whomever to be able to do their job, which is reporting what they believe is appropriate and truthful and right. And so why would we inhibit their ability to do that by allowing people to file these SLAPP suits? And by the way, they can file the suits. It's just a question of discovery and when the discovery comes out and who pays for it. That's really what this is all about.
Well, I was kind of concerned because I don't believe I was not a member of your subcommittee, and I just was kind of surprised because I don't think I could get into the prior testimony in the prior years. I tried, maybe I you know, but I just couldn't get it. And so I was a little kind of concerned about it. So,
Right. I don't recall having a testimony like we had this year in previous years. I could be wrong about that. I will tell you that the former chairman of JPR had some issues with this bill, which is maybe why, it was not dealt very favorably in the past. The former chair, my former seatmate.
I know who you're talking about.
But be that as it may, I think that what we did with how we amended it last year, we made sure to still give people the right to be able to file suits when they are legitimate suits to try and defend their position. So,
Delegate Cox.
Thanks, Mr. Chair. I remember Delegate Cardin, you worked very hard with some of us across the aisle to try to fix this bill. The problem that remains is, I know in DC, I know Delegate Moon brought this up at one point in one of the past years, that Washington, DC, when it passed a similar bill, it actually provided for limited discovery and would not penalize the parties at the discovery stage, if I recall. I don't see that in this current bill, number one. Number two, the other problem that I have is when you're saying that we're going to defend free speech, while at the time causing people who are seeking to protect their speech in court to be, basically reverse discriminated against, such that if they file suit and they happen to not prove enough of their case, now they're going to be looking at, hundreds of thousands of dollars or even worse than that of attorney's fees. So it claims to be anti-slap, while instead it actually is slapping anybody who tries to speak up in court, rather than go through the historic rules of procedure that would allow for litigation. And if the evidence isn't there, it gets thrown out. And the American rule applies, which says that everybody bears their own costs. And as I recall in committee, this was not for the little guy, like we had originally thought a couple years back. Only the Washington Post showed up for this bill, and owned by Bezos and company. I think that kind of shows where we need to be cautious we don't want to give international corporations such a massive leg up against the everyday American that might want to question what they're saying about them. So I'm going to be a no for that reason, but I do appreciate you working across the aisle, Delegate, in the past year.
So I'll say that
Delegate Cardin.
Thank you, Mr. Chairman. The people that came to testify was the Association of Broadcasters and Journalists, not at least this year and last year. There may have been others that came, but the people that we worked with to make sure that we understood the perspective of the media was not a particular newspaper. It was the association of all the journalists and newspapers.
I beg to differ, Delegate. Bezos's Washington Post lawyer was testifying. I asked him questions, if you might recall.
I'm just referring to the person who. Are you talking about this year or last year?
This year. I'm sorry. I thought you were referring to this year. Yeah.
Okay. This year. Oh well. So perhaps he did testify. I can't remember her name, but Rebecca. I think her first name was Rebecca. Is the person I'm referring to who testified as the director of the Broadcasters Association.
All right. There was a motion and a second on House Bill 70. Seeing no further hands raised for further discussion, Delegate Anderson.
Yeah, I just wanted to correct something that Delegate Cardin said. It's called the National Association of Broadcast Journalists. It's different than journalists and broadcasters, but NABJ. So just a little thing.
Okay. There was a motion and a second for favorable. Delegate Grammer in the chat. Rebecca Snyder is the person that was being discussed a moment ago. from the Maryland, Delaware, DC Press Association. In any case, there was a motion for a favorable and a second. Seeing no further discussion, we will do a roll call, and slightly differently from previous years where I've gone through the list and called them in the order in which you have been seated in the room. Someday we will go back to that. But for now, it's easier for Dylan to vote alphabetically, except for the first two, which will be the vice chair and Delegate Shoemaker. So just to give people an idea, because sometimes, change is difficult, we'll just give you a heads up that you probably need to pay attention the first couple times, and then we'll get into a routine, I suppose. All right, the vice chair, House Bill 70, this is for a favorable. The vice chair, Delegate Shoemaker.
No.
Delegate Anderson.
Yes.
Delegate Arakan.
No.
Delegate Bartlett.
Yes.
Delegate Cardin.
Yes.
Delegate Conaway.
Yes.
Delegate Cox.
No.
Delegate Crutchfield.
Yes.
Delegate Davis.
Yes.
Delegate Juanita Fisher.
Yes.
Delegate Grammer.
No.
Delegate Howell.
Yes.
Delegate Jones.
Yes.
Delegate Lopez.
Yes.
Delegate McComas.
No.
Delegate Munoz.
No.
Delegate Shetty.
Yes.
Delegate Cham.
No.
Delegate Tolles.
Yes.
Delegate Williams.
Yes.
Right. Fourteen seven, motion carries, and I'll recognize that was the very, very first vote for delegates Howell, Munoz, and Tolles in the General Assembly. So congratulations on casting your first votes. All right, we're now going to go to House Bill 92, which passed the Judiciary Committee unanimously last year. This is Delegate Hill's bill that seeks to provide assistance to people. I think it's mostly for powers of attorney to be able to file for benefits when they have a power of attorney over another person. It adds language to the existing forms for that. Is there a motion?
Move favorable. Second.
Motion for a favorable and a second. Is there further discussion on House Bill 92? Seeing none, the vice chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams.
Yes.
21. Right. House Bill 153. House Bill 153 was passed last year. 14. Okay. I'm sorry, did I miss one? Oh, I'm sorry, I did miss one. 148. Don't have the folder for 148. Staff.
It's a great bill. Let's just go ahead and pass it.
It's Delegate Bartlett's bill, if you haven't noticed. Where did I put it? Oh, wait, it's over here. Sorry, everybody. Let's go back to House Bill 148. Delegate Bartlett, do you remember what the vote was last year? This is in the same position. Oh, well, no, this is newer legislation, right? We didn't vote on this last year. All right, so that's fine. So let's have an initial, can I have a motion, please?
148, Mr. Chairman, or
148. Delegate Bartlett's bill on stalking, now that I've made it nice and confusing. Can I have a motion on the bill?
Move favorable.
A
Second.
motion for a favorable and a second. Let's have discussion. Anyone like to speak on or For or against House Bill 148? Delegate Conaway.
Thank you, Mr. Chairman. Could the good delegate please give us a little brief of what this bill does?
Delegate Bartlett.
Thank you for that question, Delegate Conaway, and thank you, Mr. Chair. The bill brings us to modern times. It alters the definition of stalking to include by electronic means as well as in person. So the problem is we didn't have in person in the statute, and we didn't have by electronic means. Very important because of all the gadgets that are coming out now that are meant for you to be able to find your phone, but unfortunately you can just to give you an analogy, it's meant for you to be able to find your phone, but you might be able to locate, and track somebody and what they're doing.
This is the AirTags, right? The Apple AirTags is
Right.
the technology you're talking about.
That's
Delegate
right.
Conaway.
Yeah, thank you, Mr. Chairman. So delegate, how does that work with these Apple AirTags, or if somebody puts one on your car or something like that? I mean, how does that work?
Well, the sad part is, can you just mute for a second? Because I think I'm going to do feedback. Okay, so the sad part is that it's a little round circle that it's like the size of a quarter almost. And you can just put it on someone's car and they don't even know it. I mean, literally, you can just walk by, put it on their car and they don't know it. And what happens sometimes is, this was the testimony, that people will get a notice on their phone that says, you are now being tracked. Is this what you wanted? And then that's how they find out that they're being tracked. And then they go to they don't know where it is on their car. So they go to the police station and they find it in their car that it was like attached under a tire, not under a tire, but that part of the tire, under that little section. You can tell I really am a great auto mechanic, but they'll find it at the police station and that someone has been tracking them. And it wasn't something that they intended to have done.
All right, Delegate Cardin.
Thank you, Mr. Chair. I don't really have a question about that part. It's the electronic communication part, and just making sure. So the definition of stalking still applies. You have to have somebody believe they've been put in imminent fear of harm or intentional infliction of emotional distress. So if I call somebody like 25 times, but I don't necessarily meet any of those qualifications, it wouldn't be considered stalking, or?
Right, exactly. So for instance, we would still use the same definition of electronic communication that's already in law, and we would still use the same definition of stalking that's already in law. For example, when the Star 69 first came out, I was calling the wrong number accidentally, right? And the person did, and I was in California, I didn't know about this. I came back to DC. They called me back and they said, "You're calling me." And I didn't realize that you could even do that. It was unintentional. So no, I wouldn't have fallen under this stalking statute. However, if I was doing it intentionally to cause harm or distress or anything like that, then yeah, I would have fallen within the new changes to the law.
All right. The Delegate McComas, then Delegate Conaway again. Delegate McComas.
Thank you, Mr. Chair. Just briefly, Delegate Bartlett, do you know what the range would be if you were going to put it on a car, to follow somebody? I mean, is it a block or a mile, or I was just kind of curious.
You know what? That's a good question, Delegate McComas, and I can look that up in a second, but it's not just a little bit. I mean, it's not just a block or a mile. I know it's more than that. I don't know the details though, but I'll put a link in the chat that has a whole article on it and to explain it a little bit, because
Thank you. I mean, it just kind of got my curiosity. I think I may need one for my phone though.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, delegate, for entertaining my questions. I was wondering if a person buys a used vehicle from a private salesperson, or maybe even one of the used lots, and they put one of these on their car, and you make a late payment and they start calling you and say, "Hey, I know where my car is. When you're going to make the payment?" would that be covered by something like this, or?
Well,
I mean, it's a real example. And I mean, I
that's
see you smiling, but it's a real example.
no, it's a good example.
Oh,
It's
I
a
know.
good example because knowing where the car is to repossess is not the current issue. You know, a lot of times they know where the car is, like it could be in your driveway, you still can't repossess. So it would still be illegal. You're not supposed to put these types of well, we don't want folks to put these types of devices on people's cars without their permission in order to go within the definition of stalking. Now, another bill may be, we might not be able to use it in the repossession of vehicles. That might be another time, another year. But this one is more in the tent of more towards intentionally causing harm, distress, emotional distress, things of that sort. And some may say that, you know, repossessing your vehicle can cause emotional distress, but that's for the courts to decide.
Okay, thank you.
You're welcome.
Delegate Erican.
Sorry, I just want to double check. So there are GPS trackers used on all rental cars. So this is not going to capture the rental car companies, right?
Not in that regard. I mean, if there were a rental car employee who was intentionally using, you know, yeah.
Okay, so okay, got it.
I don't think it would apply to somebody who was using them to track down their property. I mean, that I think is different than if they were using it to track down a person and follow them and then effectively, you know, harass and stalk them. I think there's a distinction there. If the people who come to repossess your car can come and repossess your car, they can just come and repossess your car, and so they may use that to go and repossess your car. That's not mean they're stalking you. It means they're stalking the car, and it's not illegal necessarily to do that. Delegate Juanita Fisher.
Move to previous question.
Wow, first time. Okay. There is a motion for the previous question. All in favor say aye. Opposed nay. Motion carries. We're moving on to the previous question, which was the favorable motion. There was a second. We'll go to a roll call. The vice chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes.
Carden.
Yes.
Conaway.
Yes.
Cox.
Yes.
Crutchfield.
Yes.
Davis.
Yes.
Juanita Fisher.
Yes.
Grammer.
Yes.
Howell.
Yes.
Jones.
Yes.
Lopez.
Yes.
McComas.
Yes.
Munoz.
Yes.
Shetty.
Yes.
Cham.
Yes.
Coles.
Yes.
Williams.
Yes.
21. Okay, let's go to 143, which passed 19-1 last year. This is Delegate Crutchfield's bill repealing the spousal defense. Can I have a motion on the bill, please?
Move favorable.
Motion for a favorable. Is there a second?
Second.
And a second. We'll have discussion. Does anyone wish to discuss House Bill 153? Delegate Erican.
Hi, so I just want to confirm that this still includes the fourth degree.
Delegate Crutchfield.
Yes, it does.
Okay, thanks.
All right. Delegate Conaway.
Yes, can you elaborate a little bit more on that fourth degree? What we're doing with that?
Delegate Crutchfield.
Yes, what we're doing with that is we are now eliminating that as we are doing with the spousal defense, which prohibits spouses from prosecution for sexual offenses such as rape in the first degree, second degree, as well as sexual crimes in the third and fourth degree. And that is what Delegate Erican is speaking to.
But let me be more specific. It eliminates the spousal defense in those cases, correct?
That's
It
correct.
eliminates the ability to assert a spousal defense that
Correct.
I was married to them, thus it was okay that I committed a
Yes,
rape.
a sexual crime against my spouse.
Right.
That
Okay.
is correct.
So
And it
they,
includes those offenses, rape, as well as the first, second, and third degree
right,
sexual offenses.
and the fourth degree sexual offense too, is that
Yes,
right?
That
So
is correct.
so therefore, a spouse can be guilty of the fourth degree sexual offense against their against their spouse. Is that right?
That is true with this legislation.
And what is exactly is a 4th degree sexual offense? Is that fondling? Is that, what is
That
that?
includes all of those things. That is correct.
Really?
Yes, it does.
Delegate McComas.
It's my
Yeah.
understanding that this went to a conference committee last year.
That is correct, Delegate McComas.
And that the inability to reach a consensus with the Senate was over the 4th degree sex offense.
It was over the changes in the bill. That is what it was over.
In other words, they wanted to eliminate the 4th degree and you wanted to keep it.
I wanted to keep the bill as is. That is correct.
Okay, so I just have a question. If I, let's say, my husband's washing the dishes and I just kind of whack him on the bottom, just kind of like a snap. And let's say he's a little ticked with me. I mean, is that technically, I didn't get his permission to do it. I mean, could that end up that he could prosecute me if he wanted, if he was really mad at me?
Delegate McComas, I don't believe he would be able to do that because there would have to be some intent involved with doing that. He intended to do something to you, or that you
it's reverse. It's reverse.
Right, exactly. My apologies.
Yeah,
you
right.
intended to create a sexual offense against him. Okay. In that particular instance, that sounds like that was playfulness. That is what sort of spouses, lovers do. They play with each other. And no, I do not believe that could be prosecuted.
Well, I guess, but what's the penalty for a 4th degree sexual offense?
Ooh, that's a good question. I don't have that handy.
One moment, please.
Yep.
If you'd like to go to another question, we'll go to another question and I'll get that. I'll get that information for you in just a moment. I just can't remember it off the top of my head.
So somebody else, I'm done
Right
posing
with
my
you.
problem.
Delegate Cham, and then we're going to come right back. It's all right.
Okay, thank you, Chair. I think it's all relevant to what Delegate McComas is asking. If it's just help me understand, Delegate Crutchfield.
Sure.
Another scenario, the husband smacks the wife on the bottom when she's like, "Look, I don't feel like talking. Just leave me alone. I don't feel like talking." He smacks her on the butt. Certainly, that was intentional. After she said, "I don't feel like talking. I don't feel like. Just leave me alone." He smacks her on the butt.
Mm-hmm. That sounds to me like more of an assault than sexual assault.
Okay.
Look, either party could say no. Okay. I mean, it's not about, someone just hitting someone, tapping someone. There's got to be intent involved. There's got to, depends on if there was consent. There's a lot of things involved with the prosecution. Okay. But not just simply hitting somebody on their butt, hitting somebody or touching someone on their breast necessarily. That, there's a lot more to proving a sexual assault, and especially 4th degree as well.
Delegate Conaway, but before you start, the penalty for 4th degree sex assault is a year maximum and $1,000 fine. Delegate Conaway.
Thank you, Mr. Chairman. So if 2 people are living together, they're married, they're having a rough time, they're not talking to each other, everybody's mad with each other, and then one person says, "Well, I'm going to try," and they roll up on it. The guy rolls up on his wife and grabs her and fondles her, and she says, "Don't touch me," and he continues and all of this. Now she can, because she's very angry, she's mad, she can get her pound of flesh by calling the police and charging this guy with a 4th degree sex offense. Is that correct? Just answer. I mean, I'm not trying to be disrespectful, but just answer the question.
I
want to know, when are you going to teach these? If this is going to be the law, when are you going to teach these laws? Until death or 4th degree sex offense do us apart. What about that? When are we going to learn that?
Well, what about those people that are not married and actually can charge somebody?
Let's stay on the bill. We stand on the bill. We're talking about the spousal.
All right.
On the bill.
All right, could I, Delegate Crutchfield, could I intervene just for a moment? Would it be helpful
You
to
certainly may.
read to the statute for fourth degree sex offense as it pertains, I think most importantly to what we're talking about here, and that is that what is prohibited in a fourth degree sex offense is sexual contact with another without consent of the other. What sexual contact is defined as means an intentional touching of the victim's or actor's genital, anal, or other intimate area for sexual arousal or gratification, or for abuse of either party. I think the situation that's being described where someone hits another person on the bottom, I think that wouldn't necessarily rise to a level of abuse. If a prosecutor could somehow find that it was because of sexual arousal, I think that would be something else altogether. But I think that would be a fairly unusual, perhaps, set of facts. But in any case, that's what the definition of fourth degree sex offense is. And with that, I'm going to go to Delegate Davis, then Juanica Fisher, then Shetty, then Cox, then Cham. Oh my, Delegate Davis.
Thank you, Mr. Chair. I think we're getting a little afoul of the bill. My question is for Delegate Crutchfield. Does this bill simply remove the spousal defense? You can't hurt your spouse and say it ain't against the law because that's my spouse.
That is correct, Delegate Davis. Thank you.
All right, Delegate Juanica Fisher.
Thanks, Mr. Chair. Delegate Crutchfield, doesn't this bill make marital status give women no difference in the eyes of our criminal justice system? So someone who is unmarried, who is a victim of a fourth degree sexual offense, has the same ability to pursue criminal charges as someone who is married. So therefore, we are no longer making married women second-class citizens in our criminal justice system.
That is absolutely correct. We are putting some equity to it.
All right, Delegate Shetty.
Thank you, Mr. Chair. So as much as it pains me to ask this question, I just want to confirm my understanding. We are not currently in affirmative consent state, right, Delegate?
That is correct.
Okay, so in some of the prior examples that were provided where one spouse fondles another spouse and that second person expresses they don't want that, whether or not they're mad, if they have expressed at that point that they are no longer consenting to such action, then that at that point, we're talking about it potentially being a fourth degree thing, right? So it's not that there's an assumption that, and so what this bill does is it's just like, as Delegate Fisher said, it levels the playing field for consideration of married spouses to those who are unmarried.
Correct.
Okay, so married spouses can still reach out, they can still touch their spouses, they can still connect, they can play, they can do whatever. It's once it becomes unwanted and somebody either says no, or they resist, or there's something else similar to that, that's when it becomes an issue.
And that is correct.
Okay, and still, we're talking again that it's not necessarily that somebody is automatically prosecuted and charged and sent to jail. It's that in the event that they are prosecuted, that the person who committed the alleged act would no longer, under this bill, be able to use "it's okay because I'm married to that person."
They cannot use us. That is correct.
Okay.
That their relationship as spouses cannot be used as a defense.
I continue to very much love this bill and very much appreciate your leadership on this issue. Thank you so much.
Thank you.
Before I go to Delegate Cox, I missed part 2 of sexual contact, which indicates what it does not include, and it does go to, I think, a point that Delegate Conaway was making. Sexual contact does not include a common expression of familial or friendly affection or an act for an accepted medical purpose. Not the second one, the first one. But in any case, there you go. Delegate Cox.
Well, thank you, Mr. Chair. Wanted to mention that I had a case similar to the facts that would support the fourth degree concern that has been raised. And thankfully, after 3 years, the parties reconciled and regretted the party that separated regretted the accusation. But in the meantime, if this had been in the law, the attorneys influencing the parties, the other side at the time, would have filed. The way this works out is you have a protective order filed when somebody is upset. And what happened in that case was the marital parties were in the bed together, and the one party pulled away from the other party when the party did what Delegate Conway described as rolled up on the other one. And the end result was a protective order being filed, all of these wild accusations of non-permissive sexual touching, no serious issues, just literally rubbing the shoulder, things like that. And it was permitted by, no judge is going to turn, likely no judge will turn that down because it's an affirmation under oath. And so the end result was havoc for the family, 5 kids, parties having to move all the way out of state, over 400 miles away to live with family. And then after 3 years, the person influencing the party that left turned out to be a fraud to that party, and that party came back very upset with themselves that they had made those accusations. And I just look at that and say, at the end of the day, this kind of a 4th degree simply will be practically used to continue a vendetta in these divorce and custody actions, where there'll be these really false accusations made for something that is, as Delegate Conway aptly put, to have and to hold, from this time forth and forevermore. So it overrides those vows. It creates havoc in a marital dispute that will actually harm the children and the parties involved, because there will be no basis for proving any kind of mens rea or intent, because the issue, contrary to the question to the discussion of affirmative consent, the issue is the lack of the affirmation of the party alleging a lack of actual consent. And that's the concern that I have. So for that reason, I'll be voting against it. Thank you.
Delegate Bartlett.
I just want to make sure I understand. So if my husband slaps me and doesn't leave a mark, I might be lying, or I might be telling the truth if I go to court to file against him. Is that what I'm hearing? That just because you can't see it, we can't trust the wife to tell the truth? I mean, what I don't understand, and it's not, I don't know if I have to have a question now, Mr. Chair, or not, but what I don't understand is what I'm hearing is, if we can't see it, then it must not have happened. And I thought what the issue of this bill is removing this crazy, antiquated defense of no matter what the wife says, it doesn't matter, because the husband says, it doesn't matter, because all the party has to say is, that's my property. Oh, excuse me, my spouse. I can rape them whenever I choose. That's what I'm hearing. And that's what's kind of always been a problem for me. But now if I slap my husband, or if he slaps me, maybe that's what I'm into, right? That's what I'm hearing. If I'm into that and he takes me to court, he's going to be in trouble. No matter if that is what we're into, he's going to be in trouble if he says, my wife slapped me multiple times without my consent. But if I go into court and say, my husband raped me multiple times without my consent, oh, well, she's my wife. No big deal. Goodbye. You'll all go home and live happily ever after. That's what I'm hearing. And if that's not correct, please let me know. But that's really what I'm hearing. And that's my understanding of what this bill is doing, is taking away that defense. There could be tons of other defenses. Let's not forget the defense of saying, no, she's lying is still there. The defense of saying that person is an credible witness is still there. The defense of saying that I didn't do it, prove it, is still there. All those defenses, and I know those aren't the legal terms, but all those defenses are still there. So let's not forget, we can still prove the case in court. You just don't get a pass because you're married to the person. Thanks for letting me rant, Mr. Chair.
Thank you. Delegate McComas.
The only concern that I have, I mean, I think that a wife certainly has the right to say my husband raped me and prosecute him. My concern is the fourth degree is sort of like, well, let me explain. I had a case where the guy, he didn't know the lady, and I think he thought she was nice looking. He touched her butt as she was walking into the grocery store. He got charged with fourth degree. We went to a tough judge. I think he got probation before judgment, but he got put on a registry, and he couldn't get off of it, and it caused his problems with jobs. Now, I mean, he did something really stupid, but they weren't even married. I mean, they didn't even really know each other. So I guess what I'm saying is okay, if you're married, there's a you know, let's see, women are from Venus and men are from Mars. I mean, there is a difference. I mean, and both sides see things differently. And I just think it's just making it too easy to blow things up. I just would like to get rid of the fourth degree. Otherwise, I'm good with the bill, because I think it does offer protection. But I do think that it's when people are married, it's a little bit different than if they're just living together. There is a commitment there. You know, they said, I do, and it's going to take it's not just moving out. I'm moving out. I'm taking the cat and I'm moving out. It doesn't happen that way when you're married. There's all kinds of entanglements. And so I guess what I'm saying is I'm good with the bill, just eliminate the fourth degree. And I think the Senate has already said, eliminate the fourth degree and you got a deal. So I think that, and I don't think things have changed over there that much. So that's all I think. Thank you.
Vice Chair.
Well, I was just going to move the previous question.
All right, the previous question has been moved. All in favor, say aye.
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 Opposed, nay. Motion carried. We're going to go to the roll call here. The question is on the favorable motion for House Bill 153. The Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Why does Shoemaker get to go before me anyway?
The signal to us.
Oh, okay. Oh, yeah. So what does Shoemaker vote?
Yes.
Shoemaker
voted yes.
I should vote no?
Yeah.
No. Just kidding. Yes.
No.
Yes.
Kurt, how you feeling?
We're just starting, everybody. I wasn't all this gray before I got here. I'm just saying. Erican?
No.
All right. Bartlett?
Yes.
Harden?
Yes.
Conaway?
Yes.
Cox?
No.
Crutchfield?
Yes.
Davis?
Yes.
Juanita Fisher?
Yes.
Grammer?
Yes.
Howell?
Yes.
Jones?
Yes.
Lopez?
Yes.
McComas? Sue, you're on mute. I'm sorry, Delegate McComas, you're on mute.
No.
Okay, thank you. Munoz?
Yes.
Chetty?
Yes.
Cham?
Yes.
Tolles?
Yes.
Williams?
Yes.
All right, 18-3. All right. House Bill 161 was a unanimous vote last year. We have the bill in the same position as it left the House. Is there a motion?
Move favorable.
Is there a second? And a second. Is there discussion? Delegate Anderson.
No.
Delegate Anderson has a question, or Delegate Anderson has his hand up. Delegate Anderson is looking confused.
I was looking for the unmute button, sorry.
All right,
This Delegate Shetty's bill from last year?
it is. Everybody
Okay.
voted for it.
Yeah, and the question that I thank you so much for reminding me. My question is that there is already a definition in criminal law of a vulnerable adult. And my question to counsel, who's the counsel for this? Is it
It's me, it's Lauren.
Lauren?
Yes.
Does the description of vulnerability on line 33, page 4, line 33, through line 10 of page 5, does that jive with or create any problems with the definition, the actual definition of vulnerable adult in Maryland law in 3-604?
Let me take a look at that at 3-604, but I don't think these are, I don't think these are identical. I think these are specific factors looking at, it was trying to get to, I went, hold on one second, I'm sorry, I was on the wrong page. Okay, I see what you're saying, the vulnerability of the victim and whether that squares with the definition of a vulnerable adult.
Right.
Okay, can you come back? I need a minute to check that, please.
Okay, because I think that the definition of vulnerable adult includes basically all of this, and we may not have to put it in, but and again, this is just a technical question. I'm in favor of the bill, but it might create problems if you expand the definition of vulnerable adult too much, because by doing that, you kind of exclude certain things that a judge could include.
May I?
Yes, ma'am.
Delegate Shetty, and then we can go back to Lauren too. Delegate
Thank
Shetty.
you. Yes, and I certainly welcome council's interpretation on this as well and feedback. Thank you, Delegate Anderson, for the question. So the purpose of the bill was actually intended to supplement the consideration of who should qualify as a vulnerable adult, because so often under the current law, people who otherwise have like a relationship with the individual, with the party, or other factors outside of what is currently considered vulnerable, are not included as part of that, and they are victimized under the statute, but can't be. There's no way to go after people who handle this. So the reason that we included factors for consideration was to expand upon, not limit.
Okay, and I agree with 100%. I just want to try to get it as clean as possible.
Sure.
Because the title of the bill is vulnerable adult or elderly person, right?
Yes, sir. It
Or
is.
elderly individual. And an elderly individual per this bill is considered to be somebody over 68, right?
I think so.
Okay, so you should, since I'm 72, you shouldn't probably pay any attention to me at all. That was a joke, sorry.
We always care what you have to say, Delegate.
Thank you so much. But I guess the point is that under conditions of vulnerability later on in the bill, you include age as a factor when we've decided that over 68 is a definite determination that the person is vulnerable. So those are the things I was looking at.
Right. Yes, I understand your concern on that, but there's also additional factors. So somebody who could be under 68 but have some sort of disability or illness, for example, or lack of cognitive function. They could be, 35 and have an impairment of some sort that could cause them to be vulnerable. So I think when you include age in this, again, it's not meant to limit, it is meant to be considered as a factor to supplement the consideration of the individual as vulnerable.
Okay.
But again, I welcome council's interpretation and feedback. I certainly just wanted to give her time to take a look and come to an opinion while also providing some of the context for the intent of the legislation.
Yes, thank you for that. And I did get a minute to look into it. under the family law article for vulnerable adult, it's an adult who lacks the physical or mental capacity to provide for the adult's daily needs, so that when they're investigating cases of neglect against vulnerable adults, that's the definition that's used. And I think Delegate Shetty's response about this is not a specific definition of vulnerable adult. It's just looking overall at the vulnerability of the victim as a whole. So with 10 different factors, so they can coexist, and they're operating in different spheres of the law. One being more for neglect of a vulnerable adult in order to intervene by social services, and one being under this criminal statute.
All right, thank you, Ms. Nestor.
Thank you, Delegate Anderson. Are there further questions? Seeing none, we are on the bill. There's a motion for a favorable and a second, and we'll do a roll call. The Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes.
Carden.
Yes.
Conaway. Conaway. Can you unmute yourself, Delegate Conaway? Can you give me a thumbs up or up, thumbs down? Okay, that's a yes. Cox.
Yes.
Crutchfield.
Yes.
Davis.
Yes.
Juanica Fisher.
Yes.
Grammer.
Yes.
Howell.
Yes.
Jones.
Yes.
Lopez.
Yes.
McComas.
Yes.
Munoz.
Yes.
Shetty.
Yes.
Cham.
What are I at here?
You're
What are we
unmuted
on?
already.
Yeah, I know, but what bill? 153?
161. 161. Okay.
Yes, sorry.
Tolles.
Yes.
Williams.
Yes.
21. All right. Now, 3 bills from the Vice Chair. Oh dear. First one's fun. Increasing the payment for jury service, House Bill 208.
Move favorable.
Move
Mr. Chair.
favor, second.
Oh my, there's some favorables and seconds. Delegate Moon, is it true that right now jury service is $15 a day?
Yeah, it's still going to be lame at $30 a day, but it is a doubling. So let's do it.
At least you can pay for your parking.
When's the last time we raised this, Delegate Moon?
I believe it was 2006.
My goodness. Well, I suppose we ought to do something about that. All right. I'm pretty excited, but here come questions anyway. Delegate Carden and Delegate Erican.
Well, first I'm going to move favorable, Mr. Chair, so we can have
All right,
discussion.
We already did that.
We already did that.
I just wanted to respond to Delegate Anderson and say that the Calvert Street garage is, I think, maximum of $32. So you cannot get a full payment in Baltimore City.
I want to amend the bill to $32, Mr. Chairman.
It's not in writing. No. All right. Delegate Erican.
Yeah, I was gonna say like that. Can we like have an analysis of what the real cost of doing this is? Because I don't $30 still seems like it's crap. I mean,
It is.
right. This is if we're gonna change something, shouldn't we make it? I mean, $60 sounds a little bit more reasonable, right? I mean, this
Hey,
is
it's
crazy.
not in
These
writing.
people's lives are like turned upside down for multiple days, and we
I
can't even
don't-
cover the parking.
I don't disagree with that. I think that it's, there is a significant fiscal impact. I think it's about 4.7 million for this. So I think that's why we weren't looking to go higher than that at this time. But perhaps if the Senate does something more, we can come back and look at it again and see what we would do. But at this point, that's kind of where the bill is at the moment.
Yeah, I mean, I don't like to spend money, but like some things are worth it. I feel like paying jurors would fall into my category of worth it things to spend our money on. I can think of a lot that aren't though.
I was suffering from some confusion. Delegate McComas.
Okay, I think you all need to know that the fiscal note, it's going to keep going on up. For 23, it's 3.2 million, and then by 27, it's gonna be 4.3 million. So any raising of it beyond the $30 is going to have a significant impact. The other thing I will say is now this could be wrong, so I will defer to Delegate Anderson, but a lot of the Baltimore City trials are supposed to be one-day trials. Is that correct, Delegate Anderson? That they try to do one-day trials when they do the juries?
No, not exactly.
Okay.
They tell you that you're only going to be subject to be there for one day unless you're picked for a trial. In some jurisdictions, jurors have to be in the pool for more than one day at a time before they're subject to being picked for a case. But in Baltimore, they guarantee you that you're only going to be there for that day unless you're picked for a trial.
And just a little clarification on the fiscal note. The reason that it's 3.2 in fiscal 23 is because the bill takes effect October 1st. So it doesn't raise it until October 1st. So it knocks out the first 3 months of the fiscal year, which is why fiscal 23 is lower. And then it goes up to 4.3 in fiscal 24 through ad infinitum. All right, Delegate Juanita Fisher.
Oh, move to previous question.
We're having so much fun. There's a motion for the previous question. All in favor, say aye.
Aye.
Opposed, nay. There's motion carried. All right, we're on the bill. There was a motion, somewhat strenuous motion for a favorable and a second. Seeing no further discussion, the question having been moved. The Vice Chair,
Yes.
Shoemaker,
Yes.
Anderson,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
Yes.
Crutchfield,
Yes.
Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
McComas.
Yes.
I'm sorry. McComas votes yes, but I missed Lopez.
Yes.
McComas was a yes. Munoz,
Yes.
Shetty,
Yes.
Cham,
Yes.
Tolles,
Yes.
Williams,
Yes.
all right, that's 21. Let's go now to House Bill 209, which maybe different. All right, this is the Vice Chair's bill. This goes to crime related to an unnatural or perverted sexual practice. Is there a motion?
Move favorable.
Motion for a favorable. Is there a second?
Second.
Second.
A second. All right. So we're on the bill for favorable, and we have questions. First one from Delegate Munoz.
Thank you, Mr. Chair. Vice Chair Moon, I just want to ask you a clarifying question. I just wanted to confirm that the animal crime portion in this portion is duplicative, because I was informed a new code was created to deal with that issue. I just wanted to confirm with you that that's correct.
Yeah. So thank you, Mr. Chair. Let me just refresh everyone's memory. We are repealing this section of crimes related to unnatural and perverted sex practices. It does mention some bestiality offenses, but those were recodified into a new section dealing with animal abuse that included more specific penalties like banning ownership of animals. And with that recodification, the animal welfare advocates were fine moving forward with the rest of the repeal here. You should have in your packet somewhere a letter of information from the Humane Society as to that point.
Thank you so much.
Are there further questions related to the bill? Seeing none, we will go to a roll call on House Bill 209. The Vice Chair.
Yes.
Shoemaker.
Yes.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes.
Carden.
Yes.
Conaway.
Yes.
Cox.
No.
Crutchfield.
Yes.
Davis.
Yes.
Juanita Fisher.
Yes.
Grammer,
Yes.
Howell,
Yes.
Jones,
Yes.
Lopez,
Yes.
McComas,
Yes.
Munoz,
Yes.
Shetty,
Yes.
Jam,
Yes.
Poles,
Yes.
Williams,
Yes.
staff, chair votes aye. Delegate Cox,
Thank you. Just to explain my vote, Mr. Chair.
fine.
I was unclear, and I'm still unclear on why, if this is duplicative, why it's not done with the normal course of changes for duplicative statutes, as the legislature normally does an omnibus duplicative statute bill for that. So just uncomfortable with removing animal sex crimes from the criminal statute here.
Thank you very much. It was 21-1. House Bill 272. This is changes the penalty for intercepted communications. I think we had this bill last year. I'm not sure that we voted it last year, but here we are. Yes, that's right. Okay. Is there a motion on the bill? Move favorable in a second. All right, discussion on the bill. Anybody want to talk about 272? Delegate Arcane.
Can we just get a brief overview again of what it does?
How about the vice chair, or do you want counsel? You can take your pick.
I'll take the vice chair.
All right, for
Sure.
vice chair.
Thank you. If this bill just removes the felony status and changes it to a misdemeanor. The underlying penalty is still up to 5 years, and this is for intercepting communications via wire or other electronic means. So basically, this is the kid who pled took a PBJ, I think, to felony wiretapping, was having employment issues because of the felony status. And so we're simply dropping it to a misdemeanor. In prior years, we actually tried to legalize some forms of taping, but not this year. It's just felony to misdemeanor.
Okay, so this is the one where the kid was harassing Andy Harris outside his office and videotaping him and his staff. Got it. Okay, I'm gonna be a no on this one.
Delegate Cardin.
Just Mr. Vice Chair, remind me if this is the one that you and Mr. Schellenberger sat side by side and said yes to this. Is that correct? Or no, is
That's right. This has the support from Schellenberger too. This was because part of the context of this is we had previously tried to modernize the wiretapping laws by allowing people to tape evidence of abuse against themselves and not be at risk of a felony crime for doing so. So there's a big range of cases. Again, we're not changing the fact that this is illegal. All we're doing is saying we don't believe that this is one of the most serious crime types alongside the violent crimes that ought to warrant felony status in Maryland.
Delegate Wanika Fisher.
Thank you, Mr. Chair. I actually have a question.
Oh.
Yeah, I know, but I could also do my regular song.
No, that's your question.
Okay.
Grammar's coming after you.
I know. Thank you, Mr. Vice Chair, for all your hard work on this. And I agree with you in wanting to go further. And this is a great compromise. I had this question in the hearing and I forgot to ask it. With everyone having rings on their doors, like the Ring recording with the doorbell, technically, when you having rings throughout Maryland is a violation, correct? As it stands right now, the way the law is written, and you're recording someone on your Ring device.
I honestly don't know enough about how rings work. I don't know that they're transmitting audio.
Can I answer?
There's full audio and video on a Ring.
It is. Schellenberger testified. It is.
Yes.
Yeah, so that's and so I would say that
unless you put a sign up, you have to have a sign that says you're being recorded.
You're being
recorded. That way they have to sort of visually see it, and that's sort of their consent. If they continue to be in the presence, then they're consenting after they've seen the sign. But yeah, it is a violation.
Mr. Chair, if I may further
Yes, sir.
elaborate on this, I mean, look, one of the points that came up at the hearing was that this is a very old law that contemplates, life under switchboard operated phone systems and the old copper wires. And so, I would concede there's probably a larger overhaul to be done of this entire topic. I mean, when we did police body cams, we ran into the same issue, but that was many years, 8 years ago now, and we still have just done the bare minimum, I think, in terms of recodifying those rules. We obviously are not going to solve this today, and so all I had asked this year was that we at least take the felony status off of these offenses, and I guarantee you we'll be back next year and probably beyond trying to actually fix the underlying law.
Delegate Grammer.
Very brief question. So if I'm at a rally or a protest and, and I record someone in the same way that the gentlemen have recorded the congressman, and I get convicted or charged in plea, and I get convicted as a felon under the current law, do I lose my gun rights?
I believe so. Here comes Delegate Erican waving frantically in the background, though.
Okay. If you're recording somebody in a public space, that is not a violation of our two-party recording law. It has to be in a private area or where they anticipate privacy. So no.
Well, okay.
They were inside his office and they were not permitted to even be in the office at the time. And that was, and they affirmatively stated, we do not want to be recorded. And the person continued recording after being told not to record and in a space where they had a reasonable expectation of privacy. So that, I believe, is what happened.
Delegate Moon.
Yeah, I was going to say, I think there's some debate as to how far you can take the wiretap statute into a meeting like that. But again, the point here is that the prosecutorial discretion was used, and as a result, someone didn't want to take the chances on a 5-year felony conviction. And so with the seriousness of that, they caved and have this record. But to Delegate Grammer's question, I think where he's going with this, if one is convicted of this, sure, I think certainly your firearms rights are in jeopardy, notwithstanding reasonable expectations of privacy. But if you happen to get nailed on this, that's certainly a problem for you.
5134 Public Safety Article B, you can't purchase a regulated firearm if you've been convicted of a felony.
Thank you.
Got there somehow. I don't know. All right. Are we okay? Everybody's having too much fun, so we better find out. No more questions, I think, on this bill. There was a motion and a second. We're going to go to the roll call and go Vice Chair.
Yes.
Shoemaker.
No.
Anderson.
Yes.
Erican.
No.
Bartlett.
Yes.
Carden.
Yes.
Conaway.
Yes.
Cox.
No.
Crutchfield.
Yes.
Davis.
Yes.
Juanita Fisher.
Yes.
Grammer.
Yes.
Howell.
Yes.
Jones.
Yes.
Lopez.
Yes.
McComas.
No.
Munoz.
No.
Shetty.
Yes.
Cham.
No.
Poles.
Yes.
Williams.
Yes.
Man.
All right, that is 15. 15-6, right? Yeah, probably right. I think that's right. Okay, yes, that's right. 278 was passed unanimously last year. Delegate Davis's bill on the inmate cost of living report. Any questions? Motion for a favorable, sorry, motion for a favorable in a second. Is there now any discussion on it? Here comes Delegate Shoemaker.
I hate to throw a wet blanket on this, but I do have a question. Well, I guess it's more like a comment. As a general rule, I just have this visceral disdain for reporting bills. No offense, Delegate Davis. But you know, I just don't like them. I think if government spent less time reporting and more time doing their jobs, I think, you know, it would operate more efficiently. So I mean, I just want to make that comment if I could, Mr. Chair.
Thank you very much. Delegate Grammer, do you still have your hand up from the last time? Yes, you do.
I'm good, thank
Okay. Any further questions, statements? And seeing none, there's a motion and a second. We'll go to the roll call. The Vice Chair.
Yes.
Shoemaker.
No.
Anderson.
Yes.
Erican.
Yes.
Bartlett.
Yes, I love reporting bills.
Carden.
Mr. Chair, I just don't, to explain my vote, yes. I don't know how we would know if government is doing their job, Delegate Shoemaker, unless they can report to us what they're doing.
Conaway.
Yes.
Cox.
Yes.
Crutchfield.
Yes.
Davis.
Yes.
Juanita Fisher. Juanita Fisher, who's talking to someone else.
Sorry, Mr. Chair. Yes, I don't know where we are, but I'm gonna go with yes.
It's 278, House Bill
Okay,
278.
I looked at all the bills. I knew my stance before.
We're voting on a gun bill. Just say yes.
No, it's not just say yes, but I read all the bills before. Yes, thanks, Mr. Chair.
God help us. Grammer.
Yes.
Howell.
Yes.
Jones. Delegate Jones is not there. Delegate Lopez.
Yes.
McComas.
Yes.
Munoz.
Yes.
Shetty.
Yes.
Cham.
Yes.
Tolles.
Yes.
Williams.
Yes.
I don't see Delegate Rachel Jones. She had to step away for a moment. So that's 19-1. Bill's going to pass. All right, please listen up for a moment for the floor. Going backwards in the order that we just heard these bills. Delegate Davis, you should be ready to defend 278. Vice Chair can defend his three bills that we just passed, 208, 209, 272.
Mr. Chair?
Yes. Oh, wait, there's Delegate Jones.
I have to go
You want
back
to
and
vote on the 278?
Could you give me the title again? I'm sorry.
278 is Delegate Davis's bill on the inmate cost of living report.
Yes.
Okay, that makes 20. We'll let her do that. Had to step away for just a brief moment.
Thank you.
That's fine. Delegate Shetty will do 161. Delegate Crutchfield will do 153 on the floor. Delegate Bartlett will do 148. I guess I should have just said that everybody who's on here who has a bill, who got a bill passed, is just doing it, and that would have been faster, but hey, you know, whatever. Delegate Hill, Delegate Hill's bill, I'll do that. Delegate Carden, it went through the subcommittee last time, so Delegate Rosenberg's bill, Delegate House Bill 70, will be done by you. We will be back 10 a.m. on Monday to have hearings on House Bills 1 and 837. Next week is the first of several very long weeks because we have because all the bills showed up just all of a sudden. Don't know why that happened, but they all just showed up. And so particularly on Tuesday nights, I would not be making evening plans. I certainly would not be making evening plans on Tuesday nights. Some Thursday nights are going to be a little late too. Delegate Erican.
Sorry, I just wanted to confirm. You said 10 a.m. Did you mean 1 p.m.?
No, I meant 10 a.m. We said it at 10. We weren't sure how many people were going to come in and testify, and we were trying to leave time for leadership meetings on both sides in the afternoon. And so that's why we put it earlier. As it turns out, I think we have about 45 witnesses between both bills. I'm not going to predict when we're going to be done because the last time I did that and I was, like at a reasonable hour, it turned into a really late hour. So I'm not going to suspect what time that will be. Okay. But it will be sometime after 10. All right, 10 a.m. With all of that, thank you all very much. This has been the House Judiciary Committee, and have a very nice weekend. Bye-bye.
Same to you. Bye-bye.